Okay. So kind of talk us through, you know, the decision today to plead not guilty, and then also you said some of the evidence, the only evidence that they have is a contradictory statement. Kind of walk us through that as well.
Absolutely. The alleged victim in this case is a juvenile, and the juvenile made a statement back in February that was incorporated in the court's original affidavit that would be publicly available, where the juvenile stated very specifically that no inappropriate touching occurred between himself and Ms. Spears. Perhaps with the passage of time, media attention, and the like, I believe there's been kind of a fervor around town about, you know, what this boy's involvement with her was, if any, and I think, you know, we're now seeing a completely different story out of the child. He's now saying that there was inappropriate touching and sexual contact, which was never said previously. So we have two sworn statements that are contradictory both before the court, and the argument is that that doesn't make for great evidence of guilt, which is the standard that the statute requires to hold someone without bail. All that's before the court right now are those two essentially contradictory statements.
So if you had, she violated some conditions of release by, you know, speaking to another child. Why should she be allowed to be even out and about in the community for any time of length at all?
Right, and I think that what those violations are kind of, the allegations from the violations aren't in the spirit that we typically see out of violations of conditions of release. The first violation of conditions of release was alleged, I believe, by the prosecutor in court that she was pumping gas within 294 feet of the alleged residence that she's supposed to be staying away from, and she has a 300-foot restriction. We have no idea how that was measured, where that was measured. The idea behind these conditions of release is to have an individual not having contact that would negatively impact society or the alleged victim. It's really not to stop people from going about their daily life, whether it be walking at the arena and having to drive past a home, or, you know, by some calculation being within, you know, maybe 294 feet by pumping gas. I mean, I think that that type of violation isn't typically what we expect to be prosecuted, and I don't know that Ms. Spears was on notice sufficiently really to know that was out of bounds. I mean, I think that she was thinking that was greater than 300 feet and just driving by. The second set of allegations for the violation of conditions of release that have come out today, I think that involves, and Ms. Spears disputes the recollection of the individual at the Dollar General, but she, basically what that is saying hello to a child she knows in the presence of other parties in a public space. Again, this isn't really the type of conduct that we're anticipating would be rising to the level of a violation of conditions of release under a more normal circumstance where the case hasn't kind of created such community fervor.
I assume you've spoken to your client several times over the last couple of days. What's kind of been her response to these latest allegations?
In a word, she said the allegations are disgusting. She said that this is horrendous and that this is not something she would ever do. She's horrified. She's horrified. And, you know, specifically with regard to any actual sexual touching or anything inappropriate of that nature, she is steadfast in her innocence and is incredibly upset. I mean, incredibly upset, and is curious as to why this is being said now when this was not the case in the beginning. I mean, the alleged victim said exactly the opposite.
What's your response to the argument that perhaps this boy was scared?
Well, I mean, scared of who? I mean, is he scared of the police not hearing what they want to hear now. I mean, I would think that with all this media attention on it, he would actually be more intimidated not to give people what they wanted in this time period than he would have been in the first interview. I think that, of course, he's a child, and we're not going to try to, you know, intimidate or railroad a child, but we do have to look at the facts here and say, hey, this is contradictory, and my client's procedural rights and innocence matter.
So if she is so steadfast and horrified that these allegations are not true, and she feels that she's not guilty and she didn't do anything, why even take the chance and speak to somebody that's under the age and not able? Why even risk going back to prison, going back behind bars for something so silly like saying hi?
I agree, and I think that she didn't perceive the gravity of the situation as a person who hasn't had these sexual contacts. You aren't perceiving the danger associated with something as simple as simply saying hello to someone in the Dollar General. Her circumstances are such that that is perhaps technically a violation, but I can see the reasoning of an innocent person being in a public place, seeing someone she knows and saying hi, and not putting that together as, oh, this is the type of behavior that the court is asking me to not do, because, you know, that's just a normal societal interaction.
How does she explain the accusation that there are photographs and conversations between the alleged victim and Ms. Spears?
Yeah, I mean, we haven't gotten into the meat of that part of the case yet. We haven't been presented with any of the evidence that has been alleged as far as what's on any of the Instagram accounts. We have requested the discovery actually twice, and to date, we've been given none. So I understand that there may be, I don't mean to blame the state. I understand that may just be a processing thing of downloading and getting that to us. But we have requested it twice, and we haven't received it to date. So I can't really speak to what's allegedly on it because we haven't received it.
But presumably after a month or two, you would have had the conversation that the accusation is out there, at least in the affidavit, that there's photographs and conversation. And
well, it's very difficult for me to hypothesize what that is because we haven't seen it. So to ask her very personal questions about who she had interactions with, that's just not at a place, that's not a place we're at in the process right now. Typically how it works is when you request discovery, you get the discovery fairly quickly, and then from that point the defendant and I have a conversation about this is the state's evidence and how do we want to proceed. And in that case, this case, you know, that hasn't occurred. So we were just waiting for that discovery to be disclosed, and then these sort of I don't want to call them low-level VCRs, violations of conditions of release, but we wouldn't customarily see these charged. So that was our sort of surprise, and obviously she's completely denying any type of inappropriate sexual contact.
So these allegations are pretty serious, and
Yes.
this community is not happy about it. So is it even safe for her to be out on release?
Oh, absolutely. We have a strong presumption for bail. The Vermont Supreme Court has been very clear repeatedly about someone is innocent until proven guilty, and Ms. Spears is no exception. Just because there's a community fervor around these allegations, it's just that, allegations. Ms. Spears has no prior criminal history. She has no involvement previously with children or law enforcement in a negative way. You know, we understand that the community is upset and concerned by these allegations, but that shouldn't trump her procedural due process rights or cause us to jump to any unnecessary conclusions.
But is it unsafe for her to be out on the street? Meaning, like,
Sorry.
is her safety possibly at risk because of the anger within the community?
Absolutely, that's a legitimate concern. That's a legitimate concern, but unfortunately is not a reason for continued incarceration.
Was the bail review hearing fair? Would you like to see her out today? Do you understand the decision?
I understand the allegations merit considerable thought by the judge. We would have liked to see her get out today. We thought that the inconsistencies of the statements were enough to overcome the requirement statutorily of not having great evidence of guilt. But I'm appreciative of Judge Rainville for taking the time to consider this wisely and not rush to judgment about it, and we didn't have the time allotted by the court to do that today. So I'm respectful of his decision, although it's not what we hoped.
I know you're not the prosecution, but can you explain a little bit the process of holding someone on bail or no bail, and what the judge and the state and the defense would have to meet in order to make that happen?
Sure. It's pretty straightforward. It's statutorily based. So basically, there are a few different instances in which someone can be held without bail. The one that the state is cited today is when someone is charged with felonies that have the possibility or potential for life imprisonment. And in those instances where the evidence of guilt is great, the court may, although not must, they may hold someone without bail. But the court is required to make that determination. And the court didn't make that determination today. That's important to recognize. They basically held off on making that determination. The second instance is when there's either criminal contempt of court, or if there's an act of violence that the court feels that the public safety can't be reasonably protected without holding the person without bail. Those are the primary instances in which we see that, and I do really want to reiterate that conclusion wasn't reached today. They did continue the hold without bail, but only for the purpose of exploring how to answer that question, not that they made a finding.
Do they set a date yet for next week?
Wednesday at 1 o'clock.
Wednesday.
Wednesday at 1, okay.
Yep.
Okay.
Thank you very much.
Thank you so much.
Absolutely.